All right. Well, thanks everyone who's joining us here at the Wisconsin Energy Institute, and thank you to all joining us online. This is your first time at the Sustainable Energy Seminar. My name is Scott Williams. I'm the Research and Education Coordinator at the Wisconsin Energy Institute. And the Sustainable Energy Seminar is a program that we do every other Monday in the fall and the spring semesters to bring together different faculty researchers from around campus to talk about different sustainable energy challenges and solutions that are being developed. So the goal is really to bring together multiple disciplines from the science and engineering to social sciences and humanities and policy and law to talk about the many ways that scholars in this community are understanding challenges and developing solutions. This seminar is open to the public, but is also a course for undergrad students in the Engineering for Energy Sustainability certificate, as well as the Master's in Sustainable Systems Engineering. If you have a question online, you can use the Q&A box and we'll do our best to answer that question. We'll try to answer, kind of maybe alternate between questions in the room and online. Live captioning is also a feature within Zoom if you'd like to turn that on. And with that, I'll turn it over to our guest speaker today, Steph Tai. Professor Tai, Steph Tai is a professor of law at UW-Madison, as well as the Associate Dean for Education and Faculty Affairs at the Nelson Institute for Environmental Studies. Professor Tai's scholarly research examines the interactions between environmental and health sciences and administrative law. These include the consideration of scientific expertise and environmental justice concerns by administrative and judicial systems, as well as the role of scientific dialogues in food systems regulation and the ways in which private governance incorporates scientific research. And today they'll be talking more about recent Supreme Court decisions and the Biden administration's efforts around sustainability and clean energy. So welcome.
Great. Thank you for having me here. Can you all hear me online? I hope you can. Anyway, I'm pleased to be here. And like Scott said, I'm talking about sustainable energy in the Biden administration and some of the sort of barriers to achieving some of the sustainable energy goals. Oops. And now I can't seem to switch. Let me just figure out how to move. Okay, all right. So the first thing, did that not work? What?
Did one or too many.
Oh, it did one or too many. Okay, yes, okay, all right, thank you. Yeah, so generally what I'm gonna first do is talk about the Biden/Obama administration regulatory approach. And this is the Clean Power Plan, which some of you might have heard of. And it was stopped by West Virginia versus EPA, which was a Supreme Court decision that came out last year. I'll talk about some of the reasoning behind that decision and what kind of hurdles that creates for the EPA in terms of using the Clean Air Act to move to a more sustainable energy system. Then I'll talk about the Inflation Reduction Act, which provides funding for various sustainable energy projects and infrastructure, and what's been happening now as a result of it. By the way, the Inflation Reduction Act was already drafted in anticipation of a negative Supreme Court decision in West Virginia versus EPA. So it was very anticipatory in that sense. All right, so what was the Clean Power Plan? It was initially proposed under the Obama administration in 2015, and they relied upon the Clean Air Act's provision, allowing EPA to define the best system of emissions reduction. The reason why I go into the language of the statute is that we are in a system of limited federal government, which generally means that agencies can't do anything unless expressly charged to do that thing by Congress. And what happened was the Clean Air Act did a number of things. It has provisions to set national ambient air quality standards, which is also known as the NAAQS, for various pollutants around the country. That's supposed to be set at a uniform level around the country, and then states have to design particular plans to reach the NAAQS limit. And then the EPA either approves those plans or disapproves and substitutes what's known as a FIP, or a federal implementation plan. Now, that also has some provisions for doing more specific technology-based things on new kinds of power plants and stuff. And I won't go into some of the details around that, but basically, under some of these more facility-specific kind of provisions, the Clean Air Act charges the EPA with creating a best system of emissions reduction, which is the BSER. Now, what the Obama administration did, so we have to go back for a while on this, is that the Clean Power Plan would have used the Clean Air Act to do a generation shifting approach. So they took BSER, the best systems of emissions reduction, and they looked at systems in a broad way. What is our system of energy production, right? And our overall system of energy production is tipped pretty heavily towards coal, with a mix of other types of energy sources as well. It's been moving already naturally to natural gas, by the way, due to various fluctuation in prices. But that said, it's tipped heavily towards coal. And the idea under the Obama administration was to use this best systems of emissions reduction to create a regulation, the Clean Power Plan, whereby there would be a slow phase out of coal-fired power plants, moving then to natural gas, which for the amount of power generated emits a lot less carbon dioxide because it burns much more efficiently, and then finally to renewables. There's a few other factors that went into the proposal of the Clean Power Plan. So one thing that agencies have to do to justify whatever regulation they put out is they have to make it not arbitrary and capricious. That's because of the Administrative Procedure Act, which is an act also passed in the 40s by Congress that basically gives the process that all agencies must follow in doing the things that they do. And one of the things that it does is it says that courts can overturn an agency's action if they find it to be arbitrary and capricious. So that's the threshold. Or if they find it to be not in accordance with the law. So there's two particular kinds of provisions. So not in accordance with law and also arbitrary and capricious. The two steps here, the Obama administration, EPA said, okay, well, best system of emissions reduction, that could mean system in general versus a single facility. So we can take that meaning of system, and there's a lot of meanings to it. And so we're going to say that, okay, in accordance with the law, we're going to define best systems of emission reduction as a whole, as the overall system of energy generation. They also said, okay, this action is not arbitrary and capricious for a number of reasons. One, there's climate change going on, but two, they measured co-benefits. And that was something that was taken under the Obama administration in terms of their approach to measuring cost benefits of any particular action. And so what are the co-benefits of reducing emissions? Well, like I said, coal burns a lot less efficiently and with a lot more pollutants, other kinds of pollutants that come out. There's particulate matter that comes out of coal-fired power plants. There's a lot of other types of things that are contained in coal itself that when you burn it, comes out in the form of air pollution. And so what happened was the Obama administration said, well, not only do we attempt to address climate change and also save money in the long run by moving to more efficient energy sources and more renewable energy sources, but we'll actually also help public health, right? Because people will be exposed, especially people neighboring the power plants, they'll be exposed to a lot less air pollution. And they also mentioned stuff about some of the justice-based effects of that, because a lot of low-income communities tend to be around these kinds of power plants because nobody else wants to live there. And so, it drives the costs down of those areas. Thus, these are places that low-income people can afford. So that's the system that the Obama administration came up with. I mentioned this, and this goes back a while, because what happened was there was a lot of legal drama around this, right? So what happened was that the Clean Power Plan issued in 2015, and the Supreme Court granted a stay. And this was really unusual because it hadn't even, oral argument from the challenges raised by states hadn't even been heard yet by the DC Circuit, which is the Court of Appeals to which many Clean Air Act cases go. So I probably should have started with that. The DC Circuit, a number of different states, including West Virginia, filed a challenge to the Clean Power Plan, and that got heard by the DC Circuit. So as their briefing was happening before the DC Circuit, they also filed a petition for a stay to the Supreme Court. And the Supreme Court granted that stay, 5-4 along partisan lines. What's interesting in terms of weird timing and stuff like that is that a few months later, Justice Scalia passed away. And had that happened just a few months, had he passed away just a few months earlier, or had this whole action been filed just a few months afterwards, the 4-4 would not be sufficient to grant a stay. So there's a lot of very close elements about this. What happened was, oh, I keep going through too many things. So, okay, sorry. Yeah. So partisan lines, 5-4 vote. DC Circuit still held an oral argument for this. And then before the DC Circuit reached any kind of decision on the Clean Power Plan, Trump got elected and immediately rescinded the Clean Power Plan. And what he did was he replaced it with what was called the Affordable Clean Energy Rule. It would have focused just on reducing pollutants and not even all that much coming from individual power plants. They took a different definition of best systems of emission reduction, and they said systems only applies to a facility, right? That is the system, facility by facility by facility. And they also changed how they measured benefits, right? And this is where, when people talk to me about, hey, let's perform cost benefit analysis, I always explain, well, that depends on what you choose to count as benefits and what you choose not to count as benefits, what you choose to count as harms, what you choose not to count as harms. And the Trump administration chose not to rely upon counting co-benefits that resulted from limiting or moving to more renewable energy. So they said that now when we reevaluated the same situation, it's much better to take a facility by facility approach because it's not really that much harm that's being done by these facilities because we're just not counting any of the other pollutant reducing effects. We're just looking at carbon dioxide, and to the extent that carbon dioxide is causing harm to people, it's not an immediate harm, it's very gradual and in the future. Yes.
Yeah, and that also, I was just to that point, that also depends on your definition or the valuing of the social cost of carbon, right?
Absolutely.
That they had a different valuation than the previous administration.
Yes, absolutely. So they also changed the social cost of carbon, which was a formula developed under the Obama administration and is now being used and has held up in court by the Biden administration, but it's a more refined kind of threshold. But thank you for bringing that up. Yeah, so what happened was they basically said, okay, we're going to take the more traditional approach that the regulation of power plants has occurred in the past, just a facility by facility kind of approach, not this overall system of emissions reduction. What happened then? Then the DC Circuit, because a bunch of states, basically blue states, filed a challenge to the Trump administration's Affordable Clean Energy Rule, and then the DC Circuit actually vacated that. So that got rid of there. So right now, at 2021, there was nothing. There was a stay on the Clean Power Plan that got rescinded by the Trump administration, so that's gone. And then there is the ACE rule, which also got vacated by the DC Circuit in 2021. I should confess here that I did represent a number of prominent climate scientists in an amicus brief in the 2021 case. Nevertheless, and this was weird because, as I mentioned, there's no rule around. There's no Affordable Clean Energy rule, and there's no Clean Power Plan rule. There's nothing. But the DC Circuit, the Supreme Court, still granted cert in a petition challenging the Clean Power Plan in 2021, even though there was no longer a Clean Power Plan that was active. And many observers were like, this is kind of crazy. So what happened then? The Supreme Court ended up vacating the Clean Power Plan. They struck down the Clean Power Plan. And this was despite the Biden administration, which had stepped in by then, saying, we're not going to pass the Clean Power Plan again. This is not a rule that's still existing. You should just moot this case because there's no actual rule to be challenged. And we're thinking about doing something different. The Supreme Court to that said, well, you presented us with insufficient evidence that you're not going to do this again, which is unusual because usually courts are supposed to hear cases in controversy, but there was actually nothing there. And they said that, look, they agreed with West Virginia and those states challenging the Clean Power Plan, saying that system can only mean a single facility, which is something that the dissent disagrees with. And they cite the dictionary all over the place saying, well, system has a lot of different types of meanings. Systems can mean entire network systems. That's in the plain language. As an aside, what's interesting is that you see a flip between the traditional conservative liberal models. Conservative justices are traditionally focused on what's called textualism, which is looking at the plain meaning of individual words versus the drafter's intent. But here, you see a flip side. You see the dissent pointing to the words on the page and saying, look, system can mean a lot of different things. here's a gazillion dictionary definitions of systems, all of which can encompass the place that the EPA took. So how did the majority reach that decision that system in the Clean Air Act can only mean a single facility? Well, what they did was they applied what's called the major questions doctrine, which is really kind of interesting in that it's not a doctrine that has been super thriving. Now, it's not an unheard of doctrine. The first time that the Supreme Court really raised it was in a case called, what was it? Brown and Williamson versus FDA. There, the FDA said, okay, well, the word drug is pretty capacious. It means chemical substances that lead to people having particular kinds of, reactive effects. Guess what? Nicotine does that. We're going to start regulating nicotine as a drug. And what happened with then was the Supreme Court said, wait, nicotine was used a lot during that period of time that the Federal Drug Cosmetic Act was passed. And there was no mention of this potentially applying to cigarettes, right? People were just smoking cigarettes and it was seen as much more of an everyday life kind of thing. And therefore, if Congress had actually wanted to address the regulation of nicotine, aka cigarettes at the time, it didn't have vaping then Congress would have mentioned it, right? Otherwise, they just meant other things that were normally considered drugs at the time. And the idea is that that's such a major thing for Congress to do that it should be explicit about this. One thing I should step back to say is that this is an unusual thing to do because there's also another doctrine for interpreting whether or not courts, whether or not an agency has followed a statute or acted in accordance with the law. And that's a doctrine known as the Chevron doctrine. And the idea is that there's two steps to it. The first thing is that if the statute is clear on what the agency has to do, then that solves the problem, that ends the question. But if it's unclear, if there's ambiguous language, then you go to step two and you give deference to the agency, as long as it's not some kind of crazy kind of interpretation. And what that means usually is that ambiguities in a statute get resolved by an agency. Arguably, since best system of emissions reduction, system can mean potentially a single facility or multiple facilities, then under the Chevron doctrine, the agency EPA would have gotten some kind of deference and been okay with interpreting best system of emissions reduction as an overall generation shifting approach. But the Supreme Court said that no, the major questions doctrine applies here. And what that means is that instead of giving deference to an agency's interpretation of ambiguous language, in situations where it's such a major issue and they didn't really define what a major issue is, then we're going to expect Congress to say something expressly. And as a result, they said, no, system can only mean a single facility because that's what Congress was thinking about at the time. I'm going to put a pin in that because that Chevron doctrine is also potentially up for grabs before the Supreme Court, this Supreme Court term. Like I said, there was a vigorous dissent. It was on the application of the major questions doctrine and the vagaries of it. Does it apply? Does it just apply in an ad hoc way when you don't like something and you just think it's big and you don't want big government? Hard to know, although the court's kind of slowly developing this. And they also point to the Clean Air Act and what the text of it actually says. What this means for the EPA is that as it stands, they cannot, without the express amendment by Congress, use the generation shifting approach, at least under the Clean Air Act. I'm gonna put a pin in that too, because it turns out the Inflation Reduction Act was Congress's attempt to stick in some of this, and we'll see how courts approach that. But what it can use is more traditional standards, sort of regulating in a facility by facility approach. And that seems to be the direction that the EPA is now going in. What they're doing though is they're bringing back co-benefits and the social cost of carbon. So factoring in public health effects of other pollutants that get emitted from power plants. But they're also factoring in emissions reductions that can be achieved using carbon capture technologies and potentially requiring power plants to use that. So they're factoring that into the regulatory approach, but on a facility by facility basis, as the Supreme Court said, since the Clean Air Act hasn't been amended to expressly say you can engage in a generation shifting approach. Although again, like I said, the Inflation Reduction Act does try to address that somewhat. So what happened? What is the Inflation Reduction Act? It was passed in August of 2022, and it was long in the drafting. So like I said, Congress, which was at the time had enough votes because there were more Democrats. Congress at the time was anticipating the Supreme Court coming out. Why is it doing that? I'm not even touching it. This is weird. Okay. Okay, I don't know what's going on. Maybe my down button's sticky, I don't know. But Congress at the time was already anticipating that the Supreme Court would come out with some kind of strike down of the Clean Power Plan. And how did they do that? They listened to oral arguments, which were, and counted the votes, which were pretty uniformly, at least 6 of the justices were pretty skeptical of the ability of the EPA use the Clean Air Act to regulate and shift to more renewable energy. So they were already busy drafting. And what happened was I would say that the Inflation Reduction Act, part of it was something they were intending to do already, but part of it was drafted to be a direct response to West Virginia versus EPA, especially this part that states that greenhouse gases are air pollutants. The EPA should regulate clean power plant pollution, carbon pollution under the existing Clean Air Act. Now, does this take away the major questions doctrine, since Congress did weigh in and say that, hey, we want the EPA to actually regulate carbon? That was part of the complaint from the majority in the West Virginia versus EPA case, because Congress didn't say anything in the Clean Air Act about reducing carbon emissions. Instead, they were just thinking about other types of pollutants, and that was their claim, was that this is too big and surely Congress would have addressed it. Now Congress has addressed it, but they didn't do so in the Clean Air Act. So this is still up for grabs before courts about whether or not that's sufficient to quasi-amend the Clean Air Act to more fully address carbon pollution. But you know, again, with this Supreme Court, the votes probably wouldn't be there. That said, this was Congress's attempt to try to address that. Now, it does contain a lot of incentive-based approaches. So rather than using basically sticks, as it did under the Clean Power Plan, to move away from coal-fired and ultimately natural gas-fired plants, they contain a number of carrots. And I'll go through each of these, although I am totally not a tax expert. So if you ask me tax-related questions, I'll be like just staring at you. But it doesn't use tax incentives to try to do this. And there's a suggestion, at least from the White House and a number of subsequent studies, that this is having a real benefit. Again, not a tax expert, but I have tax friends who say, yeah, these incentives do things. So let's do this again. This is weird. Okay, so there's an investment tax credit and production tax credit. There's an environmental justice sort of tax kind of thing. There's a clean energy thing that's sort of related to the investment tax credit. And then there's also just a streamlining way. Okay, I have this ghost computer. A way to streamline getting the money from the taxes. Now, how does that work? And I apologize, people on the webinar. I have no idea what my laptop is doing. It seems to have a mind of its own. Hopefully it'll stay still for a while. But the first major thing is the investment tax credit and production tax credit. And the whole thrust of it is to allow taxpayers to deduct a percentage of the cost of renewable energy systems from their federal taxes. So the idea is that because of this tax benefit, it'll incentivize people to move to cleaner methods of energy production and other types of things. So there's specific types of tax credits. So you can be eligible for both of these, investment tax credits and production tax credits. So the idea is to get investors to fund things like solar and wind technologies, using biogas generators through the municipal solid waste, doing geothermal electric generation, and tidal energy generation, right? And the idea is that, yes, people have been investing all these the whole time, but now there's an extra incentive, and it's a pretty large tax incentive. Eligible for just the ITC are certain kinds of things to help move the way into that world, right? So energy storage technologies, it's going to be extremely important, especially for the kinds of electric generation that are not consistent over time, right? That's the deal with solar power, is that you're not getting the same amount of sun all the time. There's cloud coverage, there's stuff like that. You need like energy storage capacities. Same thing with wind. You need some energy storage capacity. Municipal solid waste is a bit more of a steady stream of municipal solid waste, but you still need some kind of storage capacity to get it to the end user. So they have things like energy storage technologies, microgrid controllers, fuel cells, all these storage things. Heat pump and direct use for geothermal, other types of things like combined heat and power. And then the most important part that sometimes gets overlooked is the interconnection costs. One of the issues with moving to different power sources is that the grid is already connected, right, to the pre-existing power plants. To the extent that we are trying to invest in new types of power facilities that produce less greenhouse gases, they're going to need to get hooked up to the electric grid somehow. And so all the incentives for provided for interconnection costs are extremely important to even get this kind of system going. Eligible just for the production tax credit is biomass, landfill gas, hydroelectric, marine, and this is the first time I heard of hydrokinetic, but I guess that's the title kind of stuff. And so these are all things that there's significant tax credits for.
I might point out that this has been successful for wind and solar for many years.
Yeah.
But it's never been consistent. Now the Inflation Reduction Act has certainty for 10 years for all these technologies, and it's also expanding the types of technologies that are eligible for those credits.
Yeah, thank you for adding that. And a lot of times the incentives, at least the ones that I've been reading, so there's some federal incentives, but not as much. But there's a lot of states that have state-specific kind of incentives. I think both California had incentives for that. New York has had incentives for that. And interestingly, Minnesota didn't have tax credit incentives, but it has like a sort of trading, a cap and trade kind of thing, where they've actually shaped a lot of the Midwest region, because even though Wisconsin energy producers aren't governed by Minnesota for eligibility into their Minnesota cap and trade program, there's incentives for renewable energy there. So there's been a lot of sort of, I guess, regional and state-based kind of programs. Other stuff too. So there's additional bonuses, which I think are meant to capture various values of the Biden administration. So you can get additional tax credits if you're trying to do this entirely domestically. So the more you try to do, for example, if you're trying to develop energy storage capacities and you're using entirely domestic sort of materials, there's bonuses for that. That part is has had a little bit of controversy. So a lot of the rare earth metals that are being used for some of these storage units are located in mines that are actually very close or on sort of tribal reservations. There's a reason why that is. Part of that is that the reservation lands were not the lands that many of the tribal nations originally lived on. They were moved elsewhere to places that were seen as sort of arid, unproductive, etc. And because of that, it's moving again. I know. Because of that, there's a lot of tribes that are located near many of these mines, and so there's some controversy about the streamlining of some of these sort of mining projects that are part of this overall transformation of the energy system. That's not really exact. So there's some little controversy about that domestic part, because there's an undercurrent that, okay, we're going to be promoting a lot of mining in the U.S., but otherwise it'd be mining elsewhere too. So the mining part of this has been a concern to some groups. There's also siting in energy communities. So part of that is sort of moving some of these to where they're already. The idea is that energy communities are areas which had traditionally been used for less kind of environmental purposes, and more, and it's more of a push to move those areas to cleaner energy uses, right? So brownfields is one example. So brownfields are areas that have been on the verge of being in like Superfund land, sometimes sort of reclaimed Superfund land. But the idea is that these are areas that had been traditionally polluted, have had some sorts of cleanup work, but they contain a lot of sort of toxics. And the idea is to place some of these uses that are supposed to be more renewable, right? None of these involve presumably any kind of pollution, although again, there's some question about some of the energy storage units. That said, the idea is that, and did it move again? It did. This is really weird. Okay. The idea is that by putting these clean facilities in these places, you're at least going to move to a better energy. They're also encouraging siting in low-income communities or tribal reservations. Again, this is not energy, this is not, okay, please stop this. Why is it doing this? I don't know what's going, oh, maybe. How do I stop that? Okay, I don't know. You're right, that might be it. And I don't know how to stop that. So, okay, I'm just gonna stay here and fix it every time. So the idea is that for many low-income communities and tribal reservations, there's a lack of access to electricity in general, right? There's a lot less basically an infrastructural grid. There's a lot less energy generation. There's a lot of times that there's many kind of brownouts that happen in these areas because of this lack of access to energy generation facilities. And so the idea is to put some of that there. I don't think it's the automatic slideshow because sometimes it moves fast and sometimes it doesn't. There's also, they have incentives for use in low income housing, again, to address some of those traditional environmental justice kind of issues where many low income residences are located in areas. Wow, now it just did a totally different thing. I don't know what's going on. So use in low income housing so that residents of low income neighborhoods can have access to cleaner energy. Okay, so there's also an additional adder specifically for environmental justice, which is sort of giving additional kinds of tax credits for moving into low income communities, Indian land, certain kinds of qualified low income housing projects. The idea again is to sort of shift from the traditional lack of clean energy access that many environmental justice communities have had in the past and actually create incentives to give them access. And there used to not really be any kind of incentives, right? A lot of times the demand and the ability to buy, to sort of use the market to demand clean energy has generally been in well-off communities. And so this is sort of trying to level the playing field. What?
Is that megawatt?
Yes. Yeah. So hopefully this will just stay for a little bit. I just have a few more slides left. No. What is happening? Oh, that's a good idea. Okay, now it just did a different thing. Okay.
See if it will stop, and then maybe you'll be able to swipe or use the arrows.
Okay. All right. I'm taking off my keyboard, just using the arrows. Sorry about that. Yeah, this has never happened. So there's also tax credits that are functionally similar to the ones that I talked about earlier regarding clean energy production, but it applies to all generation facilities that have an anticipated greenhouse gas emissions rate of 0. The idea is that this allows for innovation, right? So the other ones are listed types of energy production, but they said, hey, there might be some other form of energy production that we haven't anticipated, and there is some room for development of that. Okay, so what's happened as a result? And I'm just going to talk a little bit, and this side swipe button is not working. Oh, okay, the other thing is there's tax credit monetization. Unlike other types of tax incentive programs, it allows for direct pay and transfer options to make the funding more accessible. So the idea is that you don't have to do a lot of complicated filing in order to get access to these tax benefits. All right, so I'm finally on to the next slide, the last slide, so that you don't have to worry about things being weird. So things have already happened as a result of the Inflation Reduction Act. A lot of states have said, okay, well, look, this kind of tax break, this is going to be for our residents, right? And so we want to encourage our residents to get that sweet, sweet federal money. And so what they've done is they've adopted these sort of mini Inflation Reduction Acts in order to give an additional carrot so that their residents and their resident companies will take advantage, right, of the monies available in the Inflation Reduction Act. So they've done things like additional funding for transitioning to clean energy, offering hookup kind of services, doing a lot of different types of commitments. And it's varied from state to state. And it's interesting, again, because Colorado can be kind of a mixed state, but they do want access to that money. Some of the super red states, I think, have been actually kind of avoiding that money, but it nevertheless can't really stop the companies. And companies have announced more than 110 billion in new clean energy manufacturing investments since the Inflation Reduction Act became law, according to the White House. And that includes over 70 billion in the electric vehicle supply chain and about 10 billion in solar manufacturing. And so that has led to a shift in terms of energy production. Whether or not that shift would have already happened otherwise, there's a lot of other potential drivers behind that shift. It's hard to really disentangle, but it does seem like something is happening, right? So what are we left with? We're left with the carrot option being totally on the table, right? So the carrot option is what the Biden administration appears to be using after West Virginia versus EPA. West Virginia versus EPA leaves the EPA regulatory approach with a much more limited set of options by sort of trying to at least encourage carbon capture, which again has some back and forth sort of discussions about that. That said, the language of the Inflation Reduction Act that says, hey, we do think the EPA should regulate carbon as a pollutant seems to be a direct address to West Virginia versus EPA. And we'll see how courts approach this sort of not actual amendment to the Clean Air Act, but also a separate piece of legislation that references the Clean Air Act. So that's where we stand. Any questions for anyone? Because this is pretty much it for me. Thank you.
Thank you.
Okay, yeah.
Your audience questions. I guess one question I have starting, maybe it goes back to the question about carbon capture.
Mm-hmm.
So one of the objections I'm hearing is that carbon capture shouldn't be, the BSER because it's too expensive at this point, that the utilities are kind of pushing back and saying,
Right.
You shouldn't require us to do carbon capture because it's not a cost-effective technology yet for us. Is that a fair characterization?
I think that is a fair characterization, but I think the response of the EPA would be the traditional response it's had to any kind of technological requirement, because it's required technological requirements for lots of different things in the context of fuel generation, energy generation, like scrubbers and stuff were expensive at the time. And they've always relied upon language in the Clean Air Act and also in the legislative history of the Clean Air Act that it was intended to be technology first, right? That it was intended to drive the development of technology and ultimately make it cheaper. And so I think that is pretty consistent with the approach that the EPA has taken over time. Yes.
What were the specifics of the case of West Virginia versus EPA?
What do you mean?
I mean, what was the case over?
The case was over the Clean Power Plan. So they challenged the Clean Power Plan as not being in accordance with the law, right? Because basically they were saying that the language of the Clean Air Act did not allow them to regulate energy productions as an overall system, but only facility by facility. So that was their challenge. Yeah.
Was that related to the influence of the coal industry within West Virginia?
Probably, and just generally the commitments of the executive in all of the states, because it wasn't just West Virginia, and there's also Texas, which is also fossil fuel generating state, and so yeah, that was. I mean, they I mean, in terms of if you're asking about the underlying concerns versus the legal challenges that they raised, the underlying political concerns was that a movement away from coal-fired plants and fossil fuels in general would mean sort of less economic, would mean an economic drain for those states. Yeah.
It's a likelihood that some of them, or a considerable amount of the money has been somehow allocated to the IRA will be clawed back or moved in some future Congress.
So in terms of, okay, so that's an interesting question. So if someone had already been allocated some kind of money, could there be a clawback on it? My sense is that if they'd already been allocated that money, it would be sufficient to count as some kind of property right. And that might lead to some kind of takings claim against the government, where they still need to be compensated, which in turn means that they still get the money. So that would be one avenue of it. Also, things that have sufficient property rights means that there would be due process protections connected to any kind of attempts at a clawback. And so there would be a lot of procedural sort of limitations on that. And so I think that's the kind of thing that people who had already been allocated that money would raise as claims. Now, if you're talking about if they attempt to stop the Inflation Reduction Act in a future Senate, like if they sort of amend it to stop the timeline, then they can do that. So then new people can't go in and seek tax credits under it there.
So to that point, medical situation, I guess, but imagine that manufacturers start to put inventory out there, significant amount of inventory out there in anticipation of demand, that then disappears because the money is withdrawn.
Yeah.
Is there a case in law that would?
That would be difficult, right? Because you can't, if you're in terms of sort of marketing things, like you don't have any kind of right to having a steady sort of market stream, right? Anything could happen such that
Taking a risk.
Yeah, you're taking a risk. That said, right, since there are a number of states that are already committed to that, and the states might not fluctuate nearly as much, then there is some reliability in terms of at least energy production in some particular states. There's also a separate reason for some companies to commit to it that extends outside of the Inflation Reduction Act. So not tax credit related kind of incentives, but investor incentives. So there are a lot of ESG portfolios, and you can question how, whether they're greenwash or not greenwash, but some of those portfolios do claim that they are seeking sort of more investment in renewable energy sources. And this gets back to some other stuff. California has recently passed a requirement for all companies to track their tier 1, tier 2, tier 3. Scope 1, scope 2, scope 3 emissions. So that would be the direct emissions, and then sort of goes out in terms of following the carbon footprint to indirect emissions. Because of that, if companies are concerned, the disclosure of their emissions, and this is like California has it with businesses doing, I can't remember the threshold, but a certain amount of business in California, and California is such a big state that many folks do want to do business in California, then to the extent that they don't want to disclose significant amounts of scope 1, scope 2, scope 3 emissions, then they're going to want to try to diversify their energy sources and move more towards renewables. And so I think there's an additional incentive that goes beyond the Inflation Reduction Act, but they can work together, right? If anything, some of the initial major investments might have been because they're like, okay, well, we want to take advantage of this money so long as it's available, so that in the long run, we don't have to disclose as many emissions, because we know that California is doing that, and that has been proposed by the Securities and Exchange Commission on the federal level, but that's going to be further on down the line, and a change in administrations might make that not happen. But that also has been proposed on the federal level. Does that answer your question?
Yeah.
Other questions?
There was a question on the
Okay.
So are there tax credits or benefits for investments on plants that capture carbon, if they are at the federal level or both at the federal and state level?
Yeah, so I'm not aware if there's any on the state level, although if there is, I'm going to expect California to have that because it has a pretty comprehensive carbon plan, or New York, though I don't remember seeing that in New York's plan. Wait, sorry, let me step back. So New York had both their initial sort of passage of basically climate, it was like a climate action bill or something, I can't remember the exact name of it. It had a number of different types of provisions, including sort of moving to carbon zero emissions by certain years and all that stuff. But I think in there might have been room for carbon capture. It's hard to, I did not keep track because what they laid out in their plan was also a process for developing more details. And so they had this sort of whole scoping kind of process, and I lost track of what happened after the scoping process. So they might be in there, same thing with California. On the federal side, I think arguably, carbon capture could fall under that sort of catch-all kind of bonus, right? The one that did not list specific kinds of energy generation sources, but that might be something that people can make the case falls under that.
Yeah, I'm pretty sure there are other incentives,
Yeah.
even before the Inflation Reduction Act that incentivized carbon capture.
Yeah. Just as an aside, because I was talking more about the EPA and sort of direct kind of incentives in terms of tax incentives, but there's also money in the Inflation Reduction Act that's gone to the US Department of Agriculture, and the USDA, a lot of that is developed basically deal with addressing the effects of climate change, so climate adaptation. But there is some tie-in with the sort of biogas money in there, and so there's a little bit of, it's to me kind of unclear how strong the tie-in is, but there is language in the USDA's sort of announcements about how it's spending the Inflation Reduction Act money that tie to some of the biogas production. So there might be a two-pronged promotion of biogas.
What's the advisability of pursuing a strategy like this that can be challenged so easily in courts? And
well, they can't really challenge funding kind of thing. So that's the advisability, is they're avoiding the command and control type of thing that was involved with the Clean Power Plan. That's been much more easily challenged, especially before the Supreme Court. But in terms of spending allocations, that's fairly like pure executive kind of function, and so it's less easy to challenge, but more easy to change through the political process.
so is that the characteristic that's key to successful legislation, to craft it, to deal with funding as opposed to other aspects?
Yeah, well, I think part of the reason why they were trying to deal with funding was because they were anticipating a loss on West Virginia versus EPA, and thus the removal of one tool, which is the regulatory kind of tool. And so they're like, well, what else do we have as tools? And one tool is incentives. And so that's why the focus was on a sort of incentives-based approach.
I think the other reasons that it was part of the sequestration, which doesn't need that
Right.
60 vote threshold for filibusters. So, and the parliamentarian has to define like what counts as a funding or budget issue. And so there were some things like, I can't remember it, CEPP, that was more like a portfolio, clean energy portfolio, something to that, but that got struck out because it wasn't a funding or budget issue.
Yeah. So it's sort of interesting kind of political.
I remember that, but I'm wondering if there are certain characteristics of legislation in general that make it less likely to be challenged.
Yeah, I mean, I think in general, lots of funding kind of challenges in terms of giving individuals incentives to do things. That's pretty unchallengeable unless there's some weird kind of, I would say, discrimination related to that or something. So for example, one funding challenge to some of the pandemic related measures that were directing funds for Black farmers, that has been challenged and put on hold as basically being reverse discrimination. And so those kinds of funding, but apart from that, this kind of more neutral funding directed towards particular incentives, that's been used for a long time by Congress to sort of spur on different types of projects. Yeah. Any other questions?
Thank you so much for your presentation today.
Thanks for having me here. Sorry about the weird technical difficulties and also seeing the earlier bus.
Thank you.
Take care.
All right, well, that's the last seminar of the semester, so everyone is welcome to join next semester. We'll get started at the end of January. So thanks for coming.